1 again reiterates that the inspection sketch is sufficient
Please, ma'am.
for the purpose of removal of the encroachment as rightly considered by the first appellate court. Heard so and so various papers. Having gone through exhibit P2 and P2A, it is seen that the same is a rough sketch. Though the survey number has been mentioned, the exact location of the encroachment with reference to the boundaries of the said survey number has not been categorically mentioned. The said exhibit
P1,
P2 and
P2,
P2A
P1 and P2.
would categorically indicate that there is an encroachment of 666.80 square meters at different chinages in the map, but the exact location not having been demarcated and fixed, I have the considered opinion that merely on the basis of the said inspection sketch, the removal cannot happen in a proper manner, since the adjoining properties belonging to certain other persons also. In that view of the matter, I have the considered opinion that this would be a fit case to appoint the jurisdictional DDLR as a court commissioner to firstly demarcate the boundaries of the land of the plaintiff in survey number
77 bar A bar 4.
A4,
Measuring 1 acre 78 guntas.
measuring 1 acre 78 cents, situated in 114 Danapur village, Halli Obli, Hospete Taluk, Bellary district. And upon demarcating the boundaries to clearly indicate the location at which the rail tracks enter the said property and exit the said property, with the distances from the entry to the exit clearly demarcated. Once the said demarcation is done by the commissioner, as submitted by Sri Venkatesh Karvi, learned counsel for the petitioner would have to remove the railway tracks from the said entry into the land in survey number 77 bar A4 to the point of exit,
Please.
leaving the entire land in survey number 77 stroke A4 free of any encroachment of any railway track and or any incidental thereto.
My humble submission, time may kindly be fixed.
ಮಾಡ್ತಾರ ಅದನ್ನೇ ಮಾಡ್ತಾರೆ ಈಗ.
Please.
ಅದು ಕರ್ವಿ ಅವ್ರಿಗೆ ಗೊತ್ತದೆ. Since the order is passed in the presence of both the councils, the DDLR shall carry out the survey commencing from 10:30 a.m. on 22nd February 2025. The report to be furnished to the petitioner and respondent number 1 and the respondents herein by end of day 27th February 2025. The work of removal of the tracks by petitioner number 1 to commence from 3rd March 2025 and removal to be completed by 15th March 2025.
Please, ma'am. Please, much obliged.
Much.
Brief.
Gauri Shankar Mode.
If the petition has been filed, challenging order dated
They are
10
appealing
to
for respondent number 3 to 7.
Yes, your lordship.
Yes. Yes, please.
Challenging order dated 10 to 2023 by the respondent number 2 minutes. Notes here.
There is an appeal provision under section 118, 77A order has been challenged.
This order has been passed against dead persons. Minutes. Kindly peruse page number 35 minutes. The order. Garu Shri Rustam Saab Tande Sajid Saab Dalal and Shri Gosu Saab Tande Chand Saab Dalal. They have expired in 1974 and 1981 respectively. Without bringing in the LRs, my lords, order was passed against dead persons.
Those have expired in 74.
I have produced the death certificates, my lords, on page number 27, my lords.
And Rustam Saab expired on 15/1, 1981.
Uh,
My lord,
Bosu Sahib expired in 1974, my lords, and Rustum Sahib expired in 1981.
my lord, at annexure E, page 31 may kindly be seen. Order sheet. ಅಲ್ಲಿ ಬಿ ಪೋತಿ ಅಂತ ಹಾಕಿದ್ದಾರೆ, ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಪ್ರೆಸೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ at the top.
He submitted death certificate.
Yes.
Submitted.
And thereafter, my lord,
Document
next,
andro, they submitted the death certificate.
next page 33 may kindly be seen. ನಮ್ಮ ಅಜ್ಜನ ಆಸ್ತಿ ಆಗಿದ್ದು 33 my lord.
Yes, but
Please.
for the,
ಅಲ್ಲ
for the applicants, ಅರ್ಜಿದಾರರು.
ಹೌದು.
We have brought them on record. They have not brought them on record.
ಅಲ್ಲ ಅದಕ್ಕೆ for that reason only. Respondent said, that is at page 33, R said, ನಮ್ಮ ಅಜ್ಜನ ಆಸ್ತಿ ಆಗಿದ್ದು 60 year ಬಾಕಿ gives and we
went
outside job purpose 60 years ಇಂದು ಅವರು ಉಳಿಮೆ ಮಾಡಿರುತ್ತಿದ್ದರು. ಬರಗಾಲ ಸಮಯದಲ್ಲಿ ಮಾಲೀಕತ್ವದ ಕಾರಣ ನಮಗೆ 2,000 ರೂಪಾಯಿ ಅಂತೆ 3 ಸಾರಿ ಸರ್ಕಾರದಿಂದ ಹಣ ಸಂದಾಯವಾಗಿದೆ.
That is the submission of the applicant, my lords.
Respondent R said.
Even in the order itself, it is stated we have not appeared.
ಇಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇರೋದು BMP.
ಹೌದು.
ಪಲ್ಲವರೇ NC ಬೇಣಿನ ಚೇನಿನ ಬೇಣಿನ ಇವ್ರ ಹೆಸರು
ಹುಸೇನ್ ಸಾಬ್ ದಲಾಲ್. ಅಲ್ಲ, ಡಾಟರ್ ಆಫ್ ಹುಸೇನ್ ಸಾಬ್ ದಲಾಲ್.
Hussain Saab Dalal has expired.
ಅವ್ರದೆಲ್ಲ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲಿದೆ?
Hussain Saab Dalal has expired in 2003 itself, my lords.
A said 60 years we are cultivating.
It is a submission of the applicant.
ಅಲ್ಲ, respondent.
I am the owner.
ಇದೆ, but ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲಿದೆ?
ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಕೆಳಗಡೆ ಅಲ್ಲಿ.
Even in the order, my lords, it is stated that I have not appeared, my lords. On page number 36, it may be seen, my lords.
Posted for orders ಆಯ್ತಲ್ಲಪ್ಪ. 36.
Page number 36, my lords, second para, last 4 lines. ದಿನಾಂಕ 7/1/2023 ರಂದು ಈ ನ್ಯಾಯಾಲಯದ ವಿಚಾರಣೆಗಾಗಿ ಹಾಜರಾಗಿದ್ದು ತಮ್ಮ ಪ್ರಮಾಣೀಕೃತ ಹೇಳಿಕೆಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಿರುತ್ತಾರೆ. ಎದುರುಗಾರರು ನಿರಂತರ ಗೈರು ಇದ್ದು ಅವರಿಗೆ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿದ್ರು ಅವರು ವಿಚಾರಣೆಗೆ ಹಾಜರು ಆಗಿರುವುದಿಲ್ಲ. I have not appeared.
ಮತ್ತೆ ಇದು ಆರ್ ಸೆಡ್ ಅಂತ ಹೆಂಗ್ ಬಂತು?
ಅಲ್ಲಿ it is the order sheet which has been maintained and it is produced.
ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಅಂತೂ ಇಲ್ಲ.
Death certificate of appellant produced Warsaw and death certificate of one at page 31 there is a reference.
Yes, ಅದಕ್ಕೆ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ರು.
The death certificate of applicant Warsaw and death certificate of one son.
That is of applicant itself, my lords. So not brought to the notice.
A applicant, that is the applicant.
Not for respondent.
Next, my lord, at page 32, bottom. R son produced Marana Utara, Vanshavali Agu, De Utara.
Set aside the order,
Reconsideration.
complete them and then provide them opportunity of hearing.
More submission, your lordships.
A similar order was passed by this.
They have produced the death certificate at Annexure C, your lordships. It has been registered pursuant to a criminal miscellaneous case. Annexure C, your lordships.
ಹೇಳಿ.
Pursuant to the one court order dated criminal miscellaneous 34/2016.
Yes.
The death certificate has been registered. And this is the order copy of the order passed in 34/2016, your lordships. Nowhere these petitioners have been mentioned as they are also legal heirs of Dalal. That is totally different from the what they are saying about the legal heirships.
This is only for entry.
Yes, your lordships. But at least
To enter the date of death.
that petitioner, they should have mentioned in these facts also that they are also legal heirs. In the genealogy, they should have mentioned that genealogy. Whether they have the legal heirs,
Whose obligation is it?
because they have produced the genealogy, your lordships.
Whose obligation is it? You are the applicant.
Yes, your lordship.
If they don't give it, it's your obligation.
And moreover, specifically when they have mentioned about the respondent, that they have received the compensation also, and they were present also, the locus standi about these petitioners
But the
is,
order itself says they were absent. There's a contradiction.
yes,
Which one to believe?
yes,
You have not brought them as party. Bring them as party. You have to they set it aside. You'll permit you to file necessary application. Bring the legal heirs.
yes.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the impugned order dated 10/2/23 at Annexure F, passed by his respondent number 2, is against dead persons inasmuch as the respondents shown therein are Rustom Saab, who expired on 15/1/1981, and the second respondent is Gosu Saab, who expired on 4/6/1974. And in this regard, the two death certificates have been placed on record. The petitioner claims to be the granddaughter of,
Great granddaughter
great-granddaughter of,
Rustom Saab and Gausu Saab. I have produced the genealogy. I have
Page 4.
and page 4 minutes.
great-granddaughter of Gausu Saab.
Gausu Saab.
What about Rustom Saab?
Both are my great grandfathers. They are
Aurang-
brothers. Gausu Saab and Rustom Saab are
But
brothers.
Rustom Saab did not have any children.
No, Milords. He did not have any children. Only Gausu Saab had.
Great-granddaughter of Gausu Saab. Rustom Saab not having died issueless.
Issueless.
Married or
Unmarried Milords. Unmarried Milords. He died issueless. So unmarried, he didn't even adopt Milords.
having died unmarried.
Unmarried.
Issueless, unmarried, ಎರಡು ಬರಲ್ಲ. Rustom Saab having died unmarried. It is contended petitioner is the sole surviving legal representative of Gausu Saab's family. A perusal of the impugned order would indicate that though enough opportunity has been provided, the respondents did not appear, and as such the matter proceeded with order, and the order for orders, and the orders came to be passed on 10/2/2023. The said Rustom Saab expired on 15/1/1981 and Gausu Saab having expired on 4/6/1974, much prior even to the filing of proceedings. And they consider opinion that the proceedings itself were filed against dead person and could not have continued. It was for the applicants to have filed the said proceedings in a proper manner by arraying the legal representatives deceased Rustom Saab and Gausu Saab on record. The same not having been done goes to the root of the matter, and the proceedings have been filed against dead person. The orders passed against dead person are not sustainable. As such, I pass the following order. Writ petition is allowed, a certiorari is issued. The order dated 10/2/2023 passed by respondent number 2 at Annexure F is hereby quashed. Liberty is reserved to the respondents 3 to 7 to institute appropriate proceedings by arraying the appropriate legal representatives of the deceased Rustom Saab and Gausu Saab and proceed with the matter.
At least let them,
Pending case stands disposed.
let them give the list of legal years because
ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ ಮಾಡಿದೀವಲ್ಲಪ್ಪ ನಿಮ್ಗೆ, ಅದರ್ ದೆನ್ ದಟ್ nobody is there ಅಂತ. For submission we have recorded.
because what happens is in this petitioner, one Shamshad, wife of Basha Saab Dalal, has been mentioned, and in the genealogy at least they should have mentioned that how it is.
Genealogy they have produced. One of them being brought on record is sufficient.
29.
ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ ಮಾಡಿರೋದು.
At least that genealogy ought to have been complete genealogy. That is all.
That's the only genealogy. There's nobody else.
29. Sharanabasa.
My lord, in this case, on the last occasion, the lordship has directed me to secure the original records insofar as allotment of plots under the ASHA scheme. My lord, I have secured the original records. There is no such document wherein, my lord, allotment has been made to the petitioner. In spite of notices having been issued to him to furnish, he has not produced. So the document which is produced is a created or it is fake document.
This is not available on the records.
No, it is not available.
Then file police complaint.
For that reason, we have issued several notices. He did not appear.
Complaint that he is fabricating your record.
Yes.
May I request this matter, Your Lordship, tomorrow? Any other date, Your Lordship?
We'll give you one date.
Please, Your Lordship.
ನೀವು ಒರಿಜಿನಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ you already told them what is to be done. If you come clean, we have no problem. You'll get whatever reliefs. If you're fabricating documents, you'll be dealt with strictly. Learned AGA, having secured the original record, submits that the said original records do not contain
Annexure A.
Annexure A
Please.
or any reference thereto. Learned counsel for the petitioner seeks for and is granted 1 week's time finally to place on record the original of Annexure A available with the petitioner and any incidental documents in relation thereto. If the original is not produced by next date, adverse inference would have to be drawn. The matter proceeded with by considering the above petition to be an abuse of the process of court. Relist on 24th at 2:30 PM for further hearing.
Please.
30. SM Kalwat.
Please, my lord.
Yes.
My lord, I place a short accommodation, my lord. Senior is out
My
of
lord,
station. my lord.
petitioner is encroaching the acquired land and construct the building. Already award has been passed and amount has been paid.
You're supposed to place on record the award,
Award has been passed and amount,
31/8/2017,
it will be produced, but already produced.
and the redo award dated 14/5/19. 18/12/24 order ಇದೆ.
14, 29,
Last time order.
yes, my lord, I have produced it.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಇನ್ನು ಮಾಡಿಲ್ಲ,
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
1 week time.
Counsel for respond number 2 and 3 seeks for 10 days time to comply with the order dated 18/12/24. Relist on 13th March.
My lord, interim order to be extended.
Extreme order earlier granted is extended till next day.
Please.
31. Suresh Kini.
It please, Lord. Covered by my lord's judgment, my lord, on National Highways matter, where 3A
I have
issued
entered my
without,
appearance.
Now not covered ಅಂತ.
ಇಲ್ಲ, ಅದವ್ರೇನ್ dispute ಮಾಡಲ್ಲ. I have all faith in his fairness, my lord. I don't
I
think.
have entered my appearance on 12th. My name is not shown and presence of my friend made me to search the cause list.
ಅಲ್ಲ, this was, my lord, last time we have served the copies and as directed.
ಬೆಳಗಾಂದ
ಹೌದು. ಇದರಲ್ಲಿ lordships may see, my lord, in the present petition,
Hmm.
fairly covered by, kindly see, my lord, the 3A notification issued at Annexure E.
One submission. After hearing, the lordship has granted an interim order. We want to file statement. Thereafter, the lordship shall dispose of.
Well, it is clearly evident, my
We
lord.
are not disputing insofar as
when you are issuing the notification, issue for this also.
And one more
Why
thing,
do you want to issue 2 notification? ಅದು ಯಾವ್ದು ಇದೆಯೋ ಇನ್ನೊಂದ್ಸತಿ ಇಶ್ಯೂ ಮಾಡಬೇಡಿ ಕರೆಕ್ಟ್ ಆಗಿ. Nobody will be able to find
For
fault.
that reason, the document which they have relied and made a submission insofar as the document wherein, my lord, we have stated that certain property is not necessary. On that document, my lord, we have initiated action against the said person for having issued such document without seeking permission from the higher authority. That steps have been already acted
Take
upon.
action.
They have relied on that document. Now they are seeking for quashing of the entire acquisition proceedings.
That is only one petitioner.
ಅಲ್ಲ ಅದೇ ಒಂದೇ petitioner ಹೇಳ್ತಾ
We
ಇರೋದು.
are seeing lot of fraud happening
Please.
in acquisition matters here. NHA we thought was a little better, but NHA is also part of it.
Please.
ಈ KNNL, KBJNL ಅವೆಲ್ಲ ಬೇರೆ. They are beyond redemption.
Idರಲ್ಲಿ, my lord, the speciality of this matter is, kindly see, my lord, 222. The half of the work is already over without a 3A notification. 222, my lord, is the PIL filed by some of the parties in which they say, may I persuade your lordships to see, my lord, the judgment passed by a division bench of this honorable court in September 2023. Kindly mark the date, my lord, and also see what submissions they have made at 238, my lord. May I persuade your lordships to see from 237 onwards, para 5.
Yes.
It hardly needs to be stated that population is growing exponentially. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ, as already observed, there are ordinarily beyond pale of judicial scrutiny, subject to all just exceptions, so and so. Added to this, accomplishment of the project in question is already halfway through, as it is reflected from executive engineer's report dated so and so. Kindly see the tender cost and percentage of work completed. This, my lord, is completed as on September 23, and kindly see the date of the order, my lord, 21st September 23. Now kindly see, my lord, the date of the 3A notification, which I have impugned before your lordships, which is, my lord, Annexure E at page, lord, 60, I'm sorry. Annexure E, my lord, is 129 is the relevant portion starts, which is, my lord, June 24. 14th June 24 is the 3A notification, and they submit before this honorable court that 50% of the 40+% of the work is over, even without a preliminary notification in place, and the work is still on. Work is still on, and we go, my lord.
There are 3 sets of roads.
Yes.
135 to 136, 249 to 250, 192 to 193.
Yes. All are subject matter of that 3A notification only, my lord.
All are in
How?
same.
And this work is also, lordships will see.
That such a wide gap, 138 to 250, nearly 115 kilometers apart.
Alla, idu flyover, my lord. Hubli flyover is in question, and that flyover itself was subject matter of this PIL. Kindly see, my lord, the petition averments, page 210. The appellant is the owner of land number so and so, situated at, lordships get it, my lord, 210. Same. Siddappa Kambli Road. Ide CTS number de. Ide. Same thing. Page 210, my lord. Appellant is the owner of so and so survey number, situated at Lamington Road, Siddappa Kambli Road. Land has been acquired by state government with a notification number so and so, acquired by. Andre, alli preliminary notification is, Lord, 14/6/24. That notification lapsed. 3A notification madadru, that lapsed, and subsequently, my lord, they issue another notification. Do a lapse agi 3D agdene illi 40% work complete madbiಟ್ಟು.
That is 3D notification.
Illa 3A, my lord.
3A has been issued on 12/11/24. Para 3.
Sorry, my lord.
Para 3, 12/11/24, 3D
Correct.
notification.
That notification, my lord, lapsed. That lordships will get my lord, that.
How can that lapse, Mr.?
How do that lapsed, my lord? I have produced that also.
Where is the finding to that
Yes.
effect?
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅವ್ರು ಹೇಳೋದಿಲ್ಲ ಲ್ಯಾಪ್ಸ್ ಆಗಿದೆ ಅಂತ. Lordships will get in the order, my lord, that I have produced. No, that is not in dispute. Lordships may see, my lord, that notification under which the construction happened lapsed, because within 6 months 3D was not issued. May I persuade your lordships to see page 63, my lord? Page 63, my lord. This notification, Annexure D, was issued and it lapsed. And therefore, my lord, another section 3A notification is issued at page 129.
You are now confused, trying to confuse, or are you trying to?
Illa, I'm saying
what
with
are
the
you-
conviction, my lord.
you
I'm
are
saying this with
conviction is contrary to the records here.
Sorry, my lord.
You point out to the acquisition notification of 14/6/24
Correct.
as preliminary 3A.
Correct.
As
That, my
regards
lord,
which final notification was issued on 12/11.
this notification was the earlier notification based on which, my lord, that preliminary.
But now there's a final 3D notification on 12/11/24.
Correct, my lord.
Okay.
Yes, I bow down. Now kindly see, my lord, in the light of that, this is September 24 order of the division bench, my lord.
Yes.
September 23, my apologies, my lord. 21st September 23, 222. Lordships get it, my lord.
Yes.
And now kindly see, my lord, page 238 of that order added to this, Lordships get it, my lord, 238.
Hmm.
This is the status as on September 23. Added to this, accomplishment of the project in question is already halfway through, as it is reflected from executive engineers report titled so and so. And then, my lord, they give the vehement submission of the learned so and so as admission does not serve award. That your lordships may ignore. Kindly see the percentages. So even before 3D was issued, this much of work has been completed as on 29/23. Progress recorded as on.
Yes, and we asked you a very simple question at that
Sorry,
time. Is the same notification or are there different notifications?
This was, my lord, the lapsed notification. Non-challenge madiro notification alla. ಅದಾದ್ಮೇಲೆ ಇವ್ರು ಲ್ಯಾಪ್ಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಇನ್ನೊಂದು ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರು.
14/6/24 ಗೆ 3A notification issue ಮಾಡಿದ್ರು.
Sorry, my lord. Yes.
14/6/24.
Yeah. No, prior to that, my lord, one more notification was issued.
We are not concerned with your prior to that, Mr. Prabhu.
Yes, correct, my lord. I bow down. I bow down.
Why are we concerned with
No,
that?
I bow down. 14 June 24 is the 3A notification.
So is that notification covering the entire table?
Yes. Allah. No, that is, my lord, 23 nal hagiro report. Kindly see, my lord, 238. That's what I'm pointing out, my lord. I'm sorry if I'm not making myself clear. This status report, my lord, is as on 23 itself. What I'm submitting is even before that preliminary notification is issued.
Where is the notification for this? There's no notification.
Illa, iವ್ರು ಹೇಳೋದು, lordships will see, my lord, 3A notification is an earlier notification that lapsed.
And ನಿಮ್ಗ್ ಬದ್ಲು ಅವ್ರು ಕೇಳ್.
Illa.
We'll file our detailed objections, my lord.
You can
This
just
was
hold your
canvassed-
horses.
Sorry.
This point was
Under which
canvassed.
notification was this work done?
Please, my lord.
Under which notification was this work at table at page
Now-
238 done?
Now, insofar as work is concerned, my lord, this is an elevated flyover work. The work, my lord, that is stated therein is in the government property that has commenced, not in any of the private properties. Notification for acquisition is with respect to private properties. And, my lord, the private properties are not yet touched, including their land also. So to that extent, my lord, that submission, my lord, is that it is in the private land, my lord, they have started some work, my lord. Sorry, in the government land, it's a elevated flyover. So in the government road, my lord, the work has started. No, my lord, individual's land is, my lord, touched as for my instructions without acquisition.
Under the notification, my lord, the land has to vest with the central government. Now, this land, according to them, is the government land because there is a road. This government is, my lord, state government land, even if their argument is presumed. Without a notification, they complete half of the work. They issue a 3A notification on the private land, admittedly, and now say fait accompli because 50% of the work is already over. But nimdu notification madad ನೀವು ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ because 50% work is already over. ಇಷ್ಟೇ ಇವ್ರದ್ದು idea.
We'll
This is
find
what I am submitting.
some time may be granted.
Argument.
ಇದು best plan, my lord. I am only articulating what they have done.
ಒಳ್ಳೆ argument, Mr. Elkiri. Why do you have to do this and get stuck like this?
Because of the cost escalation and all other matters, my lord, it has been taken
She
up.
doesn't give you this
Now,
right to
insofar
be
as
making
their
this
land,
kind of submissions and getting away with it.
please.
You misled the division bench by making that kind of a submission.
No, not my lords.
You're completely misled
No, PIL, not my lords. Not my
by
lords.
making this statement.
No, not my lords.
Now, by what you are clarifying, that is only on government land.
Yes, my lord.
The submission that you have made recorded in para 5 and 6 in WP 4352 of 22 is completely misleading. Fight out a matter on the basis of its merits, don't mislead. And we don't expect NHA to mislead. Private parties we come down heavily. ನಿಮ್ಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು?
No, this all will be clarified, my lord, some,
You better clarify.
yes, my lord.
You are put
Will-
on notice
Yes,
that if this is only government land and there is no acquisition done, you have obtained an order of the division bench by making these false submissions,
clarify, my lords.
which we will put back. Can't be doing that.
Please.
The submission of Sri Sridhar Prabhu, learned counsel appearing for the petitioner, is that there being no 3A notification issued, a 3D notification issued, and the earlier 3A notification having lapsed, a false statement has been made by the NHAI in WP number 2352 of 2022, inasmuch as without an acquisition being completed, the NHAI has submitted a progress report on 29/2023 that financial progress has been achieved for 41.27% and physical progress has been achieved for 43.55%, which could not have been so done without the acquisition being complete. Learned counsel for Sri Mrityunjay Alikeri,
For R1, my lords, Union of India.
who appears for respond number 1, submits that the progress report which has been submitted is only as regards the works carried out over government land and not on private land. On inquiry as to whether the percentage depicts only in relation to government land or the entire extent of project, he is unable to make his submissions today. He seeks for a week's time to obtain instructions, file his detailed statement of objections, including an answer to the above query. Objections to be filed on or before 22nd February 2025, released on 24th at 2:30 PM for further hearing.
Work is going on.
Work is going on.
ಹೌದು work is going on. Work is going on because they say it's a government land.
How can work go on if notification have been quashed?
Notification is
Stayed by
not-
this one.
Stay ಅಲ್ಲ ಇವಾಗ notification.
ಅಲ್ಲ ಇದಾದ್ಮೇಲೆ ತಮ್ಮ ಸ್ಟೇ ಆದ್ಮೇಲೆ ನಾನು ವರ್ಕ್ ಹೇಳ್ತಾ ಇದ್ದೆ ಅದು ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಇದಕ್ಕೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ ವಾಟ್ ದೇ ಆರ್ ಸೇಯಿಂಗ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ 3D is stayed ಬಟ್ ಗವರ್ಮೆಂಟ್ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಅಂತ ದಟ್ ಮೇ ಬಿ ಕ್ಲಾರಿಫೈಡ್.
Please, my lord.
Now the same stretch alignment is coming on my land. They are saying 50% is already over there and division bench has, my lord, said that this is a great work that is going on. And same stretch will be part of it.
No work is progressed. SLO is present before this honorable court. No work is coming.
The further grievance of Sri Sridhar Prabhu, learned counsel for the petitioner, is that work is progressing. Sri Mrityunjay Alikeri, on instructions from the SLO, Sri so-and-so SLO, who is present before this court, submit that the work is not going on. His submission is placed on record.
Advocate for the NHI is also present, my lord.
For number 2.
Advocate from NHA, Henry, are you on the rolls of NHA or are you the counsel appearing for NHA?
Council,
Yeah, really.
R2, respond number 2.
ಇವಾಗ ಶಿವಸಾಯಿ ಪಾಟೀಲ್
He refused to
registry is
take.
directed to correct the appearance of the counsel for respond number 1 as Sri Mrityunjay Alikeri and delete the name of Sri Venkatesh M. Karvi as that appearing for respond number 1. R2 and R3 Shivsai Patil.
No, I filed an occurrence.
ನಿಮ್ಮ ಹೆಸರು
SB Anchitgiri. SB Anchitgiri.
ಶ್ರೀ SB
SB Anchitgiri.
Anchitgiri ಬರ್ಕೊಡಿ. Submit that he has filed wakalat number for respond number 2 and 3.
No,
Registry
only
is-
2 months. 3 is a state.
Respond number 2, registry is direct print his name as such and delete the name of Sri Shivsai Sagar Ladda and Shivsai M. Patil as that appearing for respond number 2 and 3. And AGA accepts notice for respond number 3.
Yes.
Now, this whole thing about SLO, NHA and SLO state representing is also a farce. This is becoming a bigger farce than KNN. Does the SLO report to the state government or to NHA?
State government. State government. They are complicated questions.
Supposed to.
So,
Supposed to actual ಬಹಳ ಡಿಫರೆನ್ಸ್ ಆಗ್ತಾ ಇದೆ ಇಲ್ಲಿ. ಮಾಡಬೇಡಿಂಗಿಲ್ಲ. You are the state, you are big machinery. Do everything properly. Take the land, give them full compensation and go ahead. Don't show your might on poor people. Poor people ಅಂತ ಹೇಳಲ್ಲ ಶ್ರೀಧರ್ ಪ್ರಭು ಅವ್ರ client ನ.
ಅಲ್ಲ ದೇವಸ್ಥಾನ. I'm doing it pro bono.
Individual ಬೇಡ.
ದೇವಸ್ಥಾನ. 125 years old temple.
ಅಂದ್ರೆ ನೀವು ಇನ್ನ ಜಾಸ್ತಿ ಪವರ್.
ಇಲ್ಲ ಇಲ್ಲ. No, no. Only a old temple. ಅವರ ಸರ್ಕಾರದವರು at least they should be considered to temples.
No consideration for anything as long as done by law.
Grateful.
If you are doing all these kind of things, it doesn't matter if you're NHA or whatever. Don't do this.
Yes.
Follow the applicable rules and act in accordance with that. ನೀವು ಶಾರ್ಟ್ ಕಟ್ ಹೊಡೆದ್ರೆ ಅದು ಬಹಳ ಲಾಂಗ್ ಕಟ್ ಆಗುತ್ತೆ, ಎಸ್ಪೆಷಲಿ ಫಾರ್ ಯುವರ್ ಆಫೀಸರ್ಸ್.
Yes.
Relist on 24th.
Right. May I pass on these written submissions?
ಕೊಡಿ, ಅವ್ರು ಕೊಟ್ಬಿಡಿ.
ಕೊಡ್ತೀನಿ.
Written submissions filed by the counsel for the petitioner is taken on record.
24th, my lord.
25th at 2:30.
32 BV Somapur.
In the last occasion, Avinash Angadi was the directed to take notice in respect of the.
ಎಲ್ಲಿ
but,
ಅವಿನಾಶ್ ಅಂಗಡಿ?
he is not on the panel. He stated that he is not on the panel of the.
NCT ಇಲ್ವಾ?
ಇಲ್ಲ
ಸರ್ ಇದ್ದಾರೆ NCT ಗೆ.
ಅವರು ಅನೂಪ್ ದೇಶಪಾಂಡೆ.
Shri Anup Deshpande is directed to accept notice for respond number 2. Which is the direct name of Shri Avinash Angadi as that appearing for respond number 2. Relist on 19th at 2:30 PM.
Please.
ಯಾವತ್ತು ಎಕ್ಸಾಮ್ ಏನಾದ್ರು ಇದೆಯಾ?
ಎಕ್ಸಾಮ್
ಇನ್ನೂ ಇಲ್ಲ.
ಫೀ ಸ್ಟ್ರಕ್ಚರ್ ಇದ್ರ ಸಲುವಾಗಿ ನಾವು ಇದು ಮಾಡ್ತಾ
ಅರ್ಜೆಂಟ್ ಏನಿಲ್ಲ. 24th.
33 24 230. 33 MR Hiremathad.
Herein, my lord, the petitioner is the purchaser, my lord. Well, the sale deed at page number 25, annexed F and F1. The petitioner purchased the said land from respond number 7 and 8, my lord. The respondents 7 and 8 are daughters of late Somnath. The late Somnath is filed application before Assistant Commissioner under section Citizens Act, section 4, subclause 3, my lord, wherein respond number 6, she fabricated some documents and her name entered in the said properties, my lord.
Respond number 6 is.
6 Pushpanjali.
Daughter.
How is she related to 7 and 8?
She is the sister of late Somnath wife, my lord. So say, Henti Tangi. She is manipulated some documents and entered her name. That is questioned by that late Somnatha before the Assistant Commissioner. That came to be allowed, my lord. Thereafter,
Senior citizen versus senior citizen agreement.
please, my lord. That came to be allowed, and thereafter, as per order that the Somnatha has name is entered in the RTC. Thereafter, Somnatha died. After that, the Somnath elders, who is the daughters of that Somnatha, their name is entered in the RTC.
Wife and son.
Please, my lord. Thereafter, the said land, the purchased by the petitioner, and after purchasing, he is intimated to the Tahsildar, so entered his name in the documents. In the meanwhile, Pushpanjali has filed one objection, my lord. And the Tahsildar has issued the notice to the petitioner. And in the meanwhile, the Pushpanjali has questioned before the Deputy Commissioner, wherein allowed by the Assistant Commissioner that filed by the late Somnatha. And Deputy Commissioner has ordered to maintain the status quo. That is Annex H, my lord.
So appeal filed by Pushpanjali before the Deputy Commissioner
Please, Mahesh.
under the Senior Citizens Act.
Yes.
Please, Mahesh. And as per
Not
section,
maintainable.
there is no,
petition,
appeal is not
writ
maintainable.
petition. Notice ಆಗಿದೆಯಾ?
Notice is, my lord,
Notice ಆಗಿಲ್ಲ.
it's a fresh.
CGA accepts notice for respond number
1 to 5.
1 to 5. Issue notice to 6 to
6 to 7 and one more implementing application is there, my lord.
6 to 8, as also on
9 and 10, my lord.
2 of 2025, returnable by 16th April. The so-and-so at annexure G and so-and-so at annexure H are stayed till the next date of hearing.
Please.
Process fee and copies by end of day 19th, failing which the interim order will stand automatically vacated.
Please. My lord.
31 interim order.
230 mood matter, Gaurish, Subhash.
KVT ಇದೆ Gaurish.
Please, my lord, serve the copy.
GV Bhatt ಅಂತ ಬಂದಿದೆ. ಗಿರೀಶ್ ವಿ ಭಟ್. ಒಂದೊಂದ್ಸತಿ ಹೆಸರು ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಹಿಂಗೆ. ಎಸ್.
Only issue is that
Copy
in this
ಬಂದಿದ್ಯಾ?
case, served, my lord.
Petition copy ಇದೆಯಾ sir?
No conference motion.
ನೋ ಕಾನ್.
Please, please.
Please.
ಹೇಳಿ.
The only issue is that in this case, my lord, non-compliance of provision 49(1) of the Karnataka Panchayat Raj Act, my lord. Kindly see the annexure A, my lord. Page number 15,
Yes.
issued on 27/1/2025. My lord, representation was submitted on 24/1/2025. Within 3 days, the Assistant Commissioner issued a notice by fixing a no confidence motion on 19th February 2025 at 11 a.m.
19th February.
19th February, ನಾಡಿದ್ದಿಗೆ. So,
ಅಂದ್ರೆ ಆಗೋಯ್ತು.
ಇಲ್ಲ, ನಾಡಿದ್ದಿಗೆ.
Infractors dismissed.
So, my lord, in this case, my lord, they are not complied the first proviso of section 49(1) of the act, my lord.
What is it to be complied?
Please, my lord. I extracted as it is the proviso, my lord, in page number
Yes.
10, grounds, my lord. 10 days mandatory notice, my lord.
To whom?
To, my lord, that is the crux of the matter. For that reason, this reason, the Honorable Division Bench of Kalburgi Bench, my lord, yesterday stayed 2 writ petitions, my lord. My lord, where it is?
That is the interim order. We have passed final orders giving reasons for it. So we'll apply for that and you go to division bench. 10 days is for the assistant commissioner to give it to you, not for the requisitioners to give it to the assistant commissioner. The order.
Lord, full bench judgment of.
Even that is also not complied in this case. First proviso, my lord.
ನಿಮ್ಗೆ ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು ನೋಟಿಸ್?
ನಮಗೆ ಅವನ 27th. 27.
Meeting is on 19th.
Please, my lord. We are not disputing about clear 15 days notice, my lord. First proviso of section 49 clearly state that prior to that, they have to, Gram Panchayat members have to issue a clear 10 days notice, my lord.
That is
After
being
that,
made
my lord, assistant commissioner given 15 days
Page
notice.
number 113.
113.
13.
2 ವರ್ಷ ಇದ್ದಾಯ್ತು.
ಇಲ್ಲ, so ಅದನ್ನೇ, ಅದು based on that only, my lord, this was reference was kindly, it is referred to the 3 judges, my lord.
Yes.
May I pass on? 2 sets of reference orders were passed by the very same judges, my lord.
Yes.
One is in respect of July 2022, my lord, in respect of Kalburgi bench, my lord. And another one is August 2022 by this bench, my lord. May I pass 2 judgments?
Yes.
Both the references, my lord.
ಅಲ್ಲಿದೆ. Lord, 112 page number also may kindly be seen. That is the another judgment which they are that is passed in the month of August at para 18 and 19. First judgment was passed in July. Second judgment is passed on August.
August. There is an ambiguity, my lord. Kindly see the order of August, my lord. Page number 44, my lord. For that reason only, Honorable Division Bench yesterday, by quoting reasonings, my lord, kindly see page number 44, my lord.
There is no ambiguity, Gaurish.
That
What is the notice to be given to the assistant commissioner? What he has to do in 10 days?
my lord, provisions
He
of
has to explain anything.
provisions of act is very clear.
Commissioner ಏನಪ್ಪ ಮಾಡಬೇಕು ಹೇಳಿ.
He has to wait for 10 days, my lord.
For what reason?
My lord, if they are given a requisition in the pressure or something, if they may
That is not, that is only for resignation.
please, my lord, kindly see the provisions, even though, my lord, kindly see annexure same C, my lord. Annexure C of the writ petition, my lord. Provision is very clear, my lord.
Annexure C.
Annexure C, my lord.
Yes.
Page 24.
Page 24, my lord. Prior to that, I'll read the provision of law, section 49, my lord. I'll take 2 minutes of.
ಮೊನ್ನೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡೋದಲ್ಲ ಕನ್ಸೂಲ್ on this.
Prior to that,
1005364.
I'll make one more submission, my lord. After passing of these two judgments, my lord, one more judgment is passed by this bench, my lord. That was also passed by the Lordship Justice Sunil Dutt Yadav and Umesh Adiga. Even their judgments, they are not followed. It is again there says that there is an ambiguity in respect of first proviso of section 49. All these judgments were clarified about second proviso of section 49. But for first proviso of section 49 is not clarified. Hence that reason, the matter is stayed, my lord. May I pass on the interim order copy, my lord.
ಇದಲ್ಲ.
October 2022 ಗೆ, by following all these two judgments, my lord, even that was also the lordship only pointed out thereafter, my lord, after convincing the point, my lord, their interim order was granted by detailed interim order was passed, my lord. May I read that interim order, my lord?
My lord, in the writ appeal, para 10, my lord. Writ appeal order, para 10. Para 10 and 11. That is the observations made by the subsequent bench, by this honorable.
Full bench is held categorical.
Yes,
And that
Please.
has been done again.
And my lord, may I interim order, my lord, kindly. Yesterday's interim order.
Order won't apply. Full bench ಎರಡು decisions ಇದಾವೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಆ ಎರಡು ಅದನ್ನೇ ಮೆನ್ಷನ್ ಮಾಡಿ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. I'll take 1 minute of my.
They are not
ಅಲ್ಲ, kindly I may permitted to read provision.
ಓದ್ಬಿಡಿ.
Please, my lord. Section 49, motion of no confidence against the Adhyaksha and Upadhyaksha of the Gram Panchayat. Every Adhyaksha or Upadhyaksha of the Gram Panchayat shall forthwith be deemed to have vacated the office of if a resolution expressing want of confidence in him is passed by a majority of not less than 1/3 of the total number of the members of Gram Panchayat at meeting specially convened for the purpose in accordance with the procedure as may be prescribed, provided that no such resolution shall be moved unless notice of resolution is signed by not less than 1/3 of the total number of the members. At least 10 days notice has been given to the given of the intention to move the resolution. That was not complied. That is only my respectful submission.
ತಗೊಳ್ಳಿ.
I'll make one submission, my lord.
ಒಂದೊಂದು
ಅಲ್ಲ,
ಅಂತ
ಅಲ್ಲ.
ಎಷ್ಟು ಸತಿ?
Tomorrow morning, that matter is posted for first serial number 1.
Today this will get over, that tomorrow will
ಅಲ್ಲ,
be posted.
ನನಗೆ ಅದು ನಾಳೆ ಮಧ್ಯಾಹ್ನವರೆಗೆ at least morning
Sorry.
first serial number 1 ಗೆ
PGA
post
accepts
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
notice for respond number 1, 2,
1 to 3.
3, 4 ಗೆ ಯಾರು?
Okay, wait. PDO.
Four ಗಲ್ಲಪ್ಪ.
PDO Ballari.
ಅಲ್ಲ, ನಾಳೆ ಮಧ್ಯಾಹ್ನ at least ಮಾರ್ನಿಂಗ್ ಫಸ್ಟ್ ಯಾಕೆಂದ್ರೆ ಇದ್ರ ಮೇಲೆ
Shri Shivaraja Remat for 4. Shri Girish V. Bhatt accepts, who has filed caveat for
Respond number 5.
respond number 5 accepts notice for respond number 6 to 18 also. He is granted 10 days time to file wakalatnama on their behalf. Petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by the notice issued by the third respondent assistant commissioner dated 27/1/2025, fixing a meeting to be held on 19th February 2025 at 11 a.m. at the office of the Gram Panchayat for considering the motion for no confidence against the petitioner, who is the Adhyaksha of the Somasundara Gram Panchayat, Kurugodu Taluk, Bellary district. The submission of Shri Gaurish Kashampur, Learned Counsel for the petitioner, is that a requisition to the Assistant Commissioner having been submitted on 24/1/2025 at Annexure C, the notice fixing the date of meeting could not have been issued on 27/1/2025 within 3 days from the submission of the requisition notice, and this he submits is contrary to the mandatory requirement under subsection 1 of
49.
section 49 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993 Act of 93. His submission is that once a requisition is submitted to the Assistant Commissioner, the Assistant Commissioner has to wait for 10 days and thereafter issue a notice to the Adhyaksha or the Upadhyaksha, as the case may be.
ಅಲ್ಲ, that is not my submission.
Before,
ಅಲ್ಲ, ಅಲ್ಲಿ ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಅನ್ನೋದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡಿಲ್ಲ provision of law. For that reason, there is an ambiguity ಅಂತ division bench was taken view that there is an ambiguity. Please.
ಇವಾಗ ಯಾರಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು ಅದ್ದಿನದ್ದು ಹೇಳಿ?
That has to clarify. Otherwise, I'll deprive my right.
No depriving. You have been there for 2 years.
ಅಲ್ಲಿ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದಾರೆ. There is no
Assistant
clarification.
Shall not I submit that in terms of first proviso to subsection 1 of section 49, no resolution shall be moved unless notice of resolution is signed by not less than 1/2 of the total number of members, and at least 10 days notice has been given of the intention to move the resolution. His submission is that there is ambiguity in the said first proviso, inasmuch as it is not mentioned as to whom the notice of 10 days has to be given, for what purpose, and as such, the rights of the petitioner, who is the Adhyaksha, against whom the motion of no confidence is moved, will be adversely affected without this ambiguity being cleared.
Please.
Correct?
Please. And my submission, that may be taken on record, my lord. The interim order of
submission-
division bench, interim order of division bench.
That a division bench of this court, by its order dated 13th October 2022 in WP number 100415 of 2022, has also come to a conclusion that there is some ambiguity in the said provision. He also relies on the interim order,
ಅಲ್ಲಿ. In 2 writ appeals, interim order were granted.
interim order dated 10,
ಅಲ್ಲ.
13/2/2025. Sorry.
ಎರಡರಲ್ಲೂ 13.
11/2/2025. In WA number
20000
0026 of 2025.
20029 of 2025.
The division bench has stayed the order of the single bench in WP number 102077 of 2022.
And also stayed the notice issued by the Assistant Commissioner.
On the ground that 10-day notice is required to be issued in terms of first proviso to section 49(1) of the Act of 1993. Shri V.S. Kalsurmat, learned AGA, would submit that there is no ambiguity as such. The said issue has been referred to two full bench two benches of full bench strength, and both the benches have categorically held that the requirement of issuance of 10-day notice is only mandatory and not directory. And in this regard, he relies upon the decision of the full bench in ILR 2022 Karnataka 4953, more particularly para 17 and 18 thereof. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇನ್ನೂ ಒಂದು ಯಾವ್ದು
August first.
July and August, my lord. One Manjunath
Gowda.
Shankar Gowda is in July.
July,
page number Shankar Gowda.
100 and
ILR 2022 Karnataka 3691, more particularly para 17 and 18 thereof, which is reproduced hereunder for easy reference. He also relies upon one other judgment of the full bench in ILR 2022 Karnataka 4953, more particularly 17 and 18 thereof, which is reproduced hereunder for easy reference. By relying on both Shankar Gowda's case and Anumava's case, he submits that the reference of 10-day clear notice found in first proviso to section 49 has to be given to the Assistant Commissioner and not to the Adhyaksha of the Gram Panchayat. And the said finding of the full bench would be binding on this court. And as such, the further finding in both the matters that the Assistant Commissioner need not wait for 10 days before issuing a notice to the members to convene a meeting to consider the no confidence motion. In the present case, notice having been issued within 3 days is in accordance with the dicta laid down by the full benches in both the above matters. And as such, he submits the no grounds being made out, the above petition is required to be dismissed. Three.
This is the third round of litigation, my lord. First two
I have mentioned
rounds, my lord, earlier because of
G. But learned counsel appearing for respond number
3 to
5
4
to
6 to 18. ma'am.
5 5.
5 to 19.
5 to 18.
18.
5 to 18.
Submit that this is the third time that respond number 5 to 18 have moved the motion of no confidence. On the first occasion,
Yes.
First
United.
occasion in it.
First occasion, my lord, because
PDO of the Gram Panchayat endorsed.
Video.
video was
on the
assigned.
first occasion,
Video
since
signature is other mail and
the
it has been
PDO had
transferred.
affixed his signature and seal, the notice came to be quashed.
Oh.
On the second occasion,
My lord, ಅದು 10 days in the other mail. 15 days clear notice ಇರಲಿಲ್ಲ.
15-day clear notice had not been issued by the, furnished by the Assistant Commissioner, leading to the quashing of the notice. And now, on the third occasion, this issue has been raised. He submits that respond number 5 to 18 have been unable to exercise their democratic rights in moving a no confidence motion against the Adhyaksha, who has been operating as, who has been functioning as Adhyaksha from the last
2 years, my lord.
more than 2 years.
1.5 year.
Only 1.5.
ಇಲ್ಲ
2 years or
I have mentioned
15
dates.
months.
community there.
I mentioned date, my lord.
2 years old immunity ಇದೆ ಗೌರೀಶ್.
31st March.
2020.
2020.
2020.
Well, 2020
certain
is
members
election.
Last
31.
so and so.
31.
Third so and so peruse papers. The submission,
26, 2023, my lord. 26/7/2023. He's assumed as a charge of Adhyaksha.
they shall not be moved ಅಂತಿದೆಯಲ್ಲಪ್ಪ. You may succeed on a different ground. ಫಿಫ್ಟೀನ್ ಮಂತ್ಸ್ ಇವಾಗ 24 ಮಂತ್ಸ್ ಆಗಿದೆ ಅಲ್ಲ.
ಇಲ್ಲ 15
ಇಲ್ಲ
months.
ಆಗಿಲ್ಲ ಸರ್.
ಆ 1 year is
ಹಾ,
become 15 months.
ಅದ
15 months ಆಯ್ತು.
24 ಆಗಿಲ್ಲ, 15 months ಆಗಿದೆ ಸರ್. 15 months ಆಗಿದೆ ಸರ್.
Heard so and so peruse papers. The short question that would arise for consideration is whether a notice of 10 clear days is required to be furnished by the requisite to the assistant commissioner before the assistant commissioner were to issue a notice under sub rule 1 of rule 3 of the rules of 1994 in form number 2. In the present case, the requisition notice in terms of form number 1 of rule 1 of rule 3, sub rule 1 of rule 3 had been issued on
24/1/25.
24/1/2025 and received by the assistant commissioner on the very same day. The notice in form 2 of sub rule 1 of rule 3 of the rules of 1994 came to be issued to the petitioner on 27/1/2025, and it is on that basis it is contended that there is no gap of 10 days from the date on which the requisition notice was submitted to the date on which the assistant commissioner issued the notice in form number 2. The full bench in Shankar Gowda's case in the afore extracted para 17 has come to a categorical conclusion that the requirement of issuing a notice for 10 days is only directory in nature. The the full bench, having come to a conclusion that the assistant commissioner would have to fix a date of the meeting on such date which does not clash with any of his other official commitments, as he has to preside over the meeting, has held that the assistant commissioner need not wait for 10 days to expire to take action to issue notice to convene a meeting. He may, if satisfied, initiate the process by issuing the notice in form 2 and fix the date of the meeting of the members at his convenience even before the expiry of 10 days. This finding in Shankar Gowda's case was reiterated by another full bench, by the very same full bench, which was considering Hanumava's case.
In Hanumava case, word used as bound, my lord.
And the full bench again held.
That is the crux of where it is stated that it is unbound, my lord. Last para, section, page number 44, last para, my lord. Answer to the reference. In view of the above, we held that 10 days clear notice found in first proviso of section 49 of the Act has to be duly signed by the half of the members of the Panchayat, shall be submitted by the two members, signed it to the concerned assistant commissioner. Further, as held by this bench in Shankar Gowda case, the members of a Panchayat are bound to give 10 days notice in form number 1.
Para 18 not.
18.
In Hanumava's case, in para 17 and 18.
Answer to the reference, my lord.
Has held that the assistant commissioner need not wait for the expiry of 10 days before issuing a notice to the members to convene a meeting of the members to consider the motion of no confidence.
But that has been
And has placed reliance on the decision in Shankar Gowda's case. Thus, two full benches having come to a categorical conclusion that the assistant commissioner need not wait for 10 days before issuing a notice to the members to convene a meeting, I am bound by the said orders of the full benches. Therefore, the contention of Sri Gaurish Kashampur, learned counsel for the petitioner, that the Assistant Commissioner, having issued the impugned notice on 27/1/2025 at Annexure A, without waiting for 10 days, is in violation of the first proviso of subsection 1 of section 49 of the Act of 1993 is not sustainable. In that view of the matter, no grounds being made out, the petition stands dismissed. ಅದಕ್ಕೆ ಮುಂಚೆ, reference is also made to an interim order passed in writ appeal number so and so. In view of references being made to the full bench judgment, final judgments of the full bench, I have the considered opinion that the interim orders will not aid the cause of the petitioner when the full benches have held to the contrary.
Grateful. Obliged.
Orders 34, Suraj Badoli.
2 weeks time to take steps for.
There are two other connected matters. Connect with so and so. Counsel for the petitioner seeks fund is granted 10 days time to make payment of necessary process fee in respect to the unserved respondent. If needful is done by 28th February, registry is directed to issue notice to unserved respondent returned by 28th April.
Please.
35, Mrutyunjay Hedikeri.
ಏನಕ್ಕೆ preemptive order ಇಲ್ಲ? None appears for the petitioner. 3 more weeks' time is granted to the petitioner to file necessary application to bring the legal of the deceased petition number 1 on record. If needful is not done by 19th, formal orders of dismissal in respect of petition number 1 would have to be passed. Pre-list on 24th March. None appears to exhibit.
In a week I will file, my lords.
3 weeks maybe.
Great. Interim order may kindly be.
Interim order earlier granted is extended.
36, NP Vivek Mehta. NP Vivek
3
Mehta.
weeks' time is granted to the petitioner to file necessary application, bring the legal opinion of deceased, respond number 6 in 36, 12 in 36.1 on record, relist on 18th March.
37, PS Kamte.
Lord, as regards the respondent number 3 is concerned, my lord. My friend just intimated that respondent number 3 is no more. 2 weeks accommodation. My lord.
Counsel for respond number 2 and 4 submit that respond number 3 is expired. Counsel for the petitioner seeks for 3 weeks' time to file necessary application to bring legal opinion of deceased respond number 3 on record, as also to make payment of process fee in respect to the other unserved respondent. Released on 18th March.
My request for extension of interim order.
Interim order earlier granted is extended to next date.
38, SC Karakati.
Please, petitioner, respondent number 2 is avoiding the notice, your lordship. Already 2 times,
3 ಸತಿ ಹೋಗ್ಬೇಕು.
please, your lordship.
10 days time to make payment of process fee in respect to unserved
R3.
R2 and R3.
Please.
If needful is done by 28th. issue
R3 and
notice
R4 is
returned by
needful done, your lordship. R3 and R4 is needful.
R2 ಗೂ ಕೊಟ್ಬಿಡಿ.
Please.
28th April.
39, HM Darigon.
This 16 and 17.
Lord,
Darigaon Ilva.
my lord, one submission. I had filed an application with regarding to recalling of order dated wherein bailable warrant was issued.
ಕೊಡಿ.
May I pass on for R16 and R17?
Affidavit file ಮಾಡಿದ್ದೀರಾ?
The affidavit, within 2 days affidavit, my lord. Like on the principle.
Despite order date 21.
Yes, my lord, that is, I
affidavit
agree.
not filed. File ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ ಅದನ್ನ ಫೈಲ್ ಮಾಡ್ತೇನೆ by tomorrow insofar as affidavit is concerned. ಅಲ್ಲ that warrant is executed, then it will be proper.
Recall ಏನಕ್ಕೆ ಮಾಡೋಣ? Affidavit ಆದ್ರೂ ಹಾಕ್ಬೇಕಾಗಿ.
ಅಲ್ಲ by tomorrow itself, my lord, I will file affidavit.
We will have it tomorrow. ಎಷ್ಟ ಫೈಲ್?
ಅಲ್ಲ yes, my lord. Yes, yes.
Because non-filing resulted in bailable warrant.
Yes. ಅಲ್ಲ non giving information to us, my lord, for that reason lordship was pleased to pass.
ಬಿಟ್ರೆ ಆಮೇಲೆ ಅವ್ರು ಕೊಡಲ್ಲ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮೇಶನ್.
ಅಲ್ಲ my humble request, my lord, by tomorrow itself, my lord, I will file affidavit of both.
All this we are doing for you,
Yes, my lord,
that
yes.
you get
Yes,
the
yes,
information.
Noda, insofar as R16 is already, it is on record.
IA 1 of 25 has been filed under section 70 bracket 2 for recalling of
ಇದು court, ಇದು file ಆಗೈತಿ.
bailable warrant issued on 12/2/2025. Now, the AGA submit that he has received instructions now and that he would be filing necessary affidavit tomorrow. Accepting his submission, the order dated 12/2/2025, issuing bailable warrant to respond number 16 and 17 is recalled. Relist on 24th
Please.
interim order.
ಹೇಳೇನೆ.
40, VP Matpati.
But on the last occasion, the lordship has,
And is granted 10 days time to comply with office objection.
And complied today.
ಇನ್ನ ಇಷ್ಟೊಂದಿದಾವೆ.
one submission, on the last occasion, the lordship has ascertained, directed me to ascertain whether 2 awards can be passed. That matter. I am ready. On what reasons that orders have been passed, my lord, I will justify with regard to that.
Just a short facts, my lord. The matter is arising under the new Land Acquisition Act of 2014, my lord. What has happened, my lord? The other 2 connected appeals are by the beneficiary, which is the Nigam, my lord. Initially, first award was passed in the year 2017, my lord.
What is his appearances now first?
My lord,
Nagpur for R2, 3 and 5 ಇದೆ.
please.
You are appearing for
In the connected case, my lord.
SM Torne for 3 and 5 ಅಂತಿದೆ.
Please, my lord.
KNN ಅಲ್ಲಿ ನೀವು appear
Please, please, my lord. The connected appeal is filed by me, my lord.
Congratulations, KNN. So Umesh Ainapur ಹೆಸರು ತೆಗಿಬೇಕಾ?
Please.
Registry SM Torne has appeared for respond number 2, 3 and 5. Registry is directed to print his name as such and delete the name of Shri Umesh Ainapur as that appearing for 2, 3 and 5. AGA for 1 and 4. 40.1 ಕೊಡಿ.
Please. ಅದು ಓರಲ್ ಆಗಿದೆ.
Service complete ಇದರಲ್ಲಿ?
Yes. Service complete.
Service is complete, my lord.
You are appearing for the landowners.
Please.
ಇದು 40.2 ಕೊಡಿ.
Even 40.2 is also by the beneficiary. My friend is appearing for the landowners, my lord.
Service complete ಆಗಿದೆ.
Service complete ಆಗಿದೆ. Last time ಕಾಪಿನ ಸರ್ವ್ ಮಾಡಿದ್ದೇನೆ. ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅದು.
And AGA accepts notice for respond number 1 and 2. Shri VP Matpati accepts notice for respond number
2 to 16.
4 to 16. Then 2 will
3 to serial number
3 to 15 number change ಮಾಡಿದಿರಾ ಇಲ್ಲಿ.
Please.
1, 3, 4 ಶುರು ಆಗುತ್ತೆ.
My apologies, my lord.
3 to 16. Registry is there and print the name as such.
Please.
Yes.
My lord, may I just
ಯಾವ
request?
ತಗೊಳ್ಬೇಕು?
May I request for 40.1, my lord? May I request?
7,333 ಕೊಡಿ.
107,333, my lord.
Yes.
My lord, the lands were acquired and the SLO passed the first award via annexure A, my lord, which is at annexure at page number 15, dated 25/2/2019. My lord, may I take running page 25, my lord, in that award? Ink page 25, internal page 11, ink page 25, my lord.
Yes.
Paragraph number 19, Kabza Bagge, my lord. In that, the SLO states the reason that for not granting him damages and the interest therein. Against this, my
ಕಬ್ಜಾ ಪಟ್ಟಿಲ್ಲ ಅಂತ.
ಆಮೇಲೆ ಇದನ್ನ ರಿಜೆಕ್ಟ್ ಇದ್ರ ಮೇಲೆ ಅವರು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡಲ್ಲ, ಡ್ಯಾಮೇಜಸ್ ಕೊಡಲ್ಲ ಈ ಅವಾರ್ಡ್ ಅಲ್ಲಿ.
ಮಾಹಿತಿ ಪ್ರಕಾರ 27/9/1984 ರಂದು
Executive engineer states that.
One second.
ಪಡೆದಿರ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರ್ತಾರೆ.
Please, my lord. Against this point, on this, he being aggrieved, he files a reference on this point also. That reference is filed on at annexure B, my lord, page number 34.
So the SLO knew when this award was passed that possession was taken on 27/9/84.
But he doesn't give any award. He says that no need to give award. And
What is the reason?
reasons are not, my lord, he say, ಆದರೆ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಹಿಂದೆ ಭೂ ಸ್ವಾಧೀನ ಕಲಂ 1894 ಕಲಂ 16 ಪ್ರಕಾರ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರಿಗೆ ಈ ಕಚೇರಿಯಿಂದ ಕಬ್ಜಾ ನೀಡಿರುವುದಿಲ್ಲ. ಆದುದರಿಂದ ಕಬ್ಜಾ ದಿನಾಂಕದಿಂದ ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆ 2013 ಕಲಂ 80 ಪ್ರಕಾರ ಬಡ್ಡಿ ಸಂದಾಯ ಮಾಡುವ ಪ್ರಶ್ನೆ ಉದ್ಭವಿಸುವುದಿಲ್ಲ. Rightly or wrongly?
Take possession.
Please,
But you don't issue a notification of subsection 2 of section 16.
Well, that was that's the issue where that it was disputed.
Who
Then
is this SLO? Is he in service?
Subsequently, what happened? He, my friend, files a reference, my lord, by annexure B1, my lord, page number 34. May I draw lordship attention? Page number 34, my lord.
Dinesh Kumar BT.
There is furthermore some submissions. Reference ಹಾಕ್ತಾರೆ. Reference ಅಲ್ಲಿ ಈ issue ಕೂಡವೇ raise ಮಾಡ್ತಾರೆ. At page number 35, my lord, point number 4, 9 and 10.
Yes.
Reference ಹಾಕ್ತಾರೆ. In reference, my lord, issue number 6 is raised. My lord, I may be permitted to produce the LAC judgment, my lord, which is not part of the writ petition. Issue number 6, my lord.
Yes.
Whether the claimant is entitled for damages from 1984 till the date of award. This issue is answered in his favor, my lord. It is at page number 144, paragraph number 49, my lord.
Page?
Internal page 44. Sorry, my lord, there are various awards. My apologies. I'll just
46. Yes, really.
Page, my lord. Ink page 46, my lord, paragraph number 49. And the Honorable Court holds that he is entitled for damages as well as was interest. As this was the position, my lord, my friend files a writ petition seeking the same prayer with a mandamus. This Honorable Court, my lord, would annexure C, page 82 of the writ petition, my lord.
Yes.
Directs, my lord, operative portion is at page 87, my lord.
Yes.
The respondent number 4 to 6 are hereby directed to consider the representation of the petitioners dated so and so and pass appropriate orders by taking cognizance of the judgment of the Honorable Appellate Court in Balwant Singh so and so. This exercise shall be completed within a period of 4 months from the date of receipt of the order. Thereafter, the matter is before the SLO, my lord, and we file objections. Then the present impugned order for damages, that is the second award, is passed, granting damages and interest to the tune of 10 crores 80 lakhs 85,526, which is at annexure E, my lord. My humble submission before the court is, my lord, when the acquisition is under the new enactment and the SLO has already passed an award, based on the award, all the petitioners herein had filed references.
So what was awarded as damages was 9%.
Please, on the another enhanced, let me complete, sir. On the enhanced amount of the reference code plus 9% and as per section 80 of the new act, the relative interest of 15% also, my lord.
So in the reference, 9% was awarded.
Please, my lord, in the reference, my lord, 9% was also awarded.
From-
And as per section 80, provided that if such compensation, second part of the second next paragraph.
It's 15%.
Please, my lord, that is referable to section 80, my lord. And damages also ಹೇಳ್ತಾರೆ last paragraph. Therefore, the claimant is entitled for damages from the SLO for a period from the date of actual possession to the date of primary notification.
Yes.
So having obtained an award from the reference court on the issue of interest as well as damages, the second award now passed by the respondent SLO, my lord, to that extent is bad in law. Because specific.
Why did you not bring it to a notice of this court when the order was passed? In,
The petitioner
WP
did not say
10
regarding reference.
390. You were represented.
Please, my lord. Earlier counsel was there, but since it was a mandamus, it was directed to be considered, my lord. But my friend had
that there is so and so.
My friend has
came to know about it. You should have moved the court saying that this is what has happened.
Even SLO, while considering when the matter was sent to the SLO to pass appropriate orders, even SLO could have seen it. Let reference was before him only who has forwarded, and my friend himself has filed a reference. He has nowhere stated that I have also filed reference before the LAC court. In none of these earlier proceedings, he has stated that I have filed reference on the same issue. The matter was for mandamus.
You are supposed to have been formed for that purpose only, for better efficiency. We don't see any efficiency in your organization at all.
My hands are tied.
Hands are tied. Allah.
Even SLO Mungadenu.
Company is also to be tied and put into that river. Yes, Ms. Matpati.
My lord, as per the direction of this court, earlier at the time of award, I submitted the representation to the SLO in the 2017. Then I'll file a writ petition before this honorable court.
ಅಲ್ಲಪ್ಪ ಇಲ್ಲಿ ನಿಮ್ ಫೇವರ್ ಎಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ. ಪೇಜ್ 48 ಕೊಟ್ಟಿದ್ದೀರಾ ಅಲ್ಲಿ?
ನೋಡಿದ್ದೀನಿ.
ಪೇಜ್ 48 ಈಚ್ ಅವಾರ್ಡ್ ಅಲ್ಲೂ ನಿಮ್ಗೆ ಆಗಿದೆ.
But it is not in multiple awards, my lord. The continuation of the award.
And what do you have to say? You have to challenge it. If you are not happy with it, you have to challenge it. You cannot suppress it and say award agilla ant helakagalla.
My lord, position was taken on 1984. We are entitled the interest.
You are entitled. 9% order ಮಾಡಿದ್ದಾರೆ.
9% only the enhanced market value, the 72, section 72 is applies. My lord.
Yes, but rightly or wrongly, an award has been passed. Can you ask for another?
They are also challenged before in the MAPA, my lord. All the judgments will be, they are challenged. Nigamul challenged.
ಮಾಡಬೇಕಲ್ಲ ಅವರನ್ನು ಮಾಡಬೇಕು.
ಮಾಡಿದ್ದಾರೆ ಸರ್ ಆಲ್ರೆಡಿ ಎಲ್ಲದರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
Why are you maintaining this writ petition if you challenge that? ಯಾವುದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ?
The present
LAC judgment ಎಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
Reference ಅಲ್ಲಿ
you
challenge the reference.
We have challenged.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
And you have challenged this here.
Please, because before you could have challenged in the interim, the SLO has passed now the second award. So not only 12 lakhs plus interest of 9% plus interest of 15%, but this 10 crore 30 lakhs in addition with interest. So the SLO could have held that I have already forwarded the reference to the reference authority, and my friend could have stated that LAC is disposed of. Award is passed on issue number 6.
In the 2017, I filed.
Adu disclose agidre idu would not trouble your this honorable court again and again in the writ petition. Since it was a mandamus, all the counsel said it could.
ನಾವು ಇರೋದು ಟ್ರಬಲ್ ಗೆನೆ, ಡೋಂಟ್ ವರಿ.
ಅಲ್ಲಮ್ಮ
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ ನಾವು ಹೇಳ್ಬೇಕಿತ್ತು. ನಮ್ಗೆ it was our duty to find out whether reference is filed. Even It was duty of all the councils there.
Not the duty of the councils, it was the duty of your officers to verify if there's a reference order which had been passed. If they don't
First-
even know what is happening in their backyard,
Please, that is there. We have already put up and told this, my lord, and even before the SLA also, but this,
if somebody had not brought it now, 10 crores would have just gone like that.
please, definitely. That's,
Yes, Ms. Madhpati, is it deliberate suppression or?
No, my lord, the thing is that we are representing you are giving the representation to the SLO, then it will be challenged.
Award had been passed much earlier on.
madam, award is passed on.
Award is passed on before this judgment, my lord.
After the judgment,
Yeah,
the
ma'am.
SLA has
No,
not given the date, my lord. The impugned award is not dated.
ನಿಮ್ಮ letter ಕಳಿಸಿದ್ದಾರೆ
The date,
ಅವರು ಸರ್
I heard,
Representation was on,
representation before the SLO is filed on 2017, my lord. 2016, 1/7/2016. At the time of passing the award, I filed a representation to give the interest from the date.
13th March 23 is the order passed by this court,
please, madam.
directing consideration
Please,
Yes, ma'am.
in terms of so-and-so judgment. Alva, when was this reference passed?
reference was filed on, my lord, 25/3/2017.
It was filed whenever. When was the judgment passed?
Judgment was passed on in a LAC, my lord,
LAC in
27/5/24.
24.
24. madam.
ಎಲ್ಲ ಆದ್ಮೇಲೆ LAC
ಅಲ್ಲ.
ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ.
Already evidence late ಮಾಡಿದ್ರು ಅವರು, issues ಫ್ರೇಮ್ ಆಗಿದ್ರು.
ಎಲ್ಲ issues frame ಅಲ್ಲಿ evidence ತಗೊಂಡು
My
ನಾವು
lord,
ಮಾಡ್ತೀವಿ.
may summon the order sheet of the LAC court, my lord, in that case.
27/5/24 is this order.
Yes, ma'am. LAC order is in the month of May.
Now, the fact remains that when the representation was submitted,
This LAC court had not, there was no finding on issue number 6, my lord, as on that date.
when the representation was submitted, SLAO had
Rejected, declined,
the claim for
please,
damages.
for damages as well as interest.
So they had approached, they had given the representation rightly
Please,
and had approached this court rightly in WP 106/390 of 2017.
please, madam.
Yes,
In
17.
17 in the 23 was
17
ಸುಮ್ನೆ
reference
ಕೂತಿದ್ರಿ.
ಹಾಕ್ತಾರೆ. Reference ಅವತ್ತೇ ಹಾಕ್ತಾರೆ.
ಅಲ್ಲ, they are not
Reference also
contesting in
filed. May I see
the
the
read
reference?
petition also they are
May I
they have
request to
submitted.
see the date of reference? That is on March 2017 reference is filed.
LAC judgment is in the month of May 24.
And the matter is disposed of in the year 2023. For 4 years, the writ petition for mandamus is not moved.
What did you do?
My lord, we were, our counsel, in LAC we appeared, my lord.
You were appearing here also.
No, I think, my lord,
By that time, all the
When the
matters
matter
were
was listed,
proceeding in the
Madam.
LAC. You chose not to bring it to the notice of this court. You were a party there. Your conduct is not clear.
my lord, since.
Or is their conduct?
ಅಲ್ಲ, ಅದು mandamus ಇದ್ದಾಗ, subject to my corrections, what my friend says. When this matter was listed on, my lord, 29th March 2023 for mandamus on the writ petition, whether prior to that the council was intimated or take notice ಮಾಡಿ the order ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ, I am subject to correction what my friend has to say. Because from 17 till 2023, the matter is not moved, but on 29th March 2023, when the order for considering the mandamus,
ನೋಡಿ, ಓಪನ್ ಮಾಡಿ, ಕೇಸ್ ಸ್ಟೇಟಸ್ ಓಪನ್ ಮಾಡಿ. WP 106390 of 2017. 17 106390.
and it is their case, it is extracted in para 2 of the writ petition order. Being aggrieved by inaction ಅಂತ ಹೇಳ್ತಾರೆ, but award ಅಲ್ಲಿ already reject ಆಗಿದೆ ಅದು. Void annexure A, his prayer or his representation as regards damages and interest is not considered as on the date of deciding the writ petition. My lord.
But number representation, they have not endorsed any endorsement. They are giving the representation in the 2016. My lord.
March notice ಆಗಿದೆಯಾ ಯಾವ parents ಮುಂಚೆನೇ ಸರ್ವಿಸ್ ಆಗಿದೆ. I brought it to the notice. Registry is directed to put up the file in WP 106390 of 2017. Yarappa. Registry is directed to put up the file in WP 106390 of 2017. Relist
So one more submission.
19th at 2:30 p.m.
Not one more submission. There were two writ petitions were filed before this court. That is 106390 of 2017 and 107176 of 2023.
107176
76 of 20, wherein allowed total 23 survey numbers were acquired, out of which initially 19 survey numbers were approached and thereafter 5 members approached this honorable court, seeking the same relief insofar as claiming damages. So, my lord, pursuant to this orders passed by this honorable court, both the awards which have been now they want to seeking for awards have been passed. Knowingly or unknowingly, my lord, the Nigama would have brought to the notice of this honorable court while pendency of the reference court, LAC court.
Problem with this Nigam and your state is you transferred it to Nigam saying Nigam will take care. You stop taking care.
My lord,
They also don't do it. When an order goes against them, they blame it on you.
yes, that
They come before us. And in the meanwhile, they have messed up everything.
so pursuant to
All the matters we are seeing,
yes, yes,
not one or two. ಮೊನ್ನೆ ಇವ್ರು MRC Ravi ಅವರು
Yes,
ಆರ್ಗ್ಯುಮೆಂಟ್
yes.
ಮಾಡಿದ್ದು ಅದೇ.
how
Everything is the same. Why do you need to be in existence? If you can't do it, wind it up. You are creating more problems than what you are required to solve.
and moreover, my lord, pursuant to the directions issued by this honorable court in both the writ petitions, notice were issued to them and they were heard, and thereafter this orders.
We are going to observe that here. It's for the state to take a decision as to why this company has to be in existence after messing up so much. You have been you and the client has been the cause for thousands of litigations, unnecessary litigations. You are claiming only on money, the land loser is not getting anything. Your SLO, you make him sit in your own office and write awards as you want. ಏನೋ ಬರೀರಿ ಆಮೇಲೆ ನೋಡೋಣ ಹಂಗೆ ಆಗಿರೋದು ನಿಮ್ದು. You are riding roughshod on everybody. And because your managing director is also IAS officer, the SLO is a KS officer, he listens to what is said. Sitting here in your own office. ಅದು affidavit ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು ಅದರಲ್ಲಿ.
Please.
ಇದೆ ಅಡ್ರೆಸ್ ಎಲ್ಲ ಕೊಡಿ.
Yes, I will keep the present.
You are becoming the boss there.
That may not be the case.
Caesar's wife ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ.
My lord, in serial number 40, I will comply today I will
Comply ಮಾಡಿ ಅಷ್ಟು.
ಮಾಡಿದೀನಿ.
Well, compliance to be made.
ಮಾಡಿದೀನಿ sir.
And counsel for the petition submit, compliance has been made, registry to verify.
My lord,
Yes, Mr. Annapur.
my lord, as regards other two connected,
ಅಪ್ಪಣ್ಣವರಿದ್ದಾರೆ.
my lord, as regards to other two, today I have to, some typed copies are not necessary, sir. Please.
41, Nagraj,
Please,
Pallava.
I am for the petitioner lordship. Lordship, office objection is lordship, acknowledgement with respect to petition number 1, petition number 5 not forthcoming lordship. Lordship, my submission is lordship, petitioner number 4 and 5 are brothers lordship, equally cultivating the land lordship. Hence, Tahsildar has issued only one endorsement, that is annexure A3 lordship.
is kept pending for now. ಏನಿದು?
Seeking regularization, consideration their unauthorized cultivation applications. Pending.
Cannot be considered. Each of you will be entitled to one unit. If you are not applied, it cannot be taken.
Acknowledgement.
4.788. ಎರಡು
Please, Lord.
application ಹಾಕಿದ್ದೀರಾ?
Totally 7 applications, Lord.
7 application.
Petition number 4 is my elder brother, Lordship.
Separate application ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ,
ಒಬ್ಬೊಬ್ಬರಲ್ಲಿ
ಇಲ್ಲ,
ಒಂದೊಂದು application ಹಾಕಿದ್ದೀರಾ? ವಿಸ್ತೀರ್ಣ 3 acre.
In respect of respond number 4 and 5, only one application, Lordship.
Anyway, consider whether
Yes.
they are in cultivation or not. Accepting the submission of counsel for the petitioner, office objection is overruled. Petitioner and AG accepts notice for respond number 1 to 7. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the application submitted by the petitioners for regularization of their unauthorized construction ಯಾವತ್ತು
19/2022
in 2022 has not
And
been
14th
considered by
2019.
despite a lapse of time. Whenever any application is submitted for regularization or otherwise, the state authorities are required to consider the same and either approve, accept or reject the said application. Needless to say, if the application is rejected, reasons have to follow. Neither having been done, I pass the following order. Writ petition is allowed. A mandamus is issued directing respondent number 1 to 5 to consider the application submitted by the petitioner at annexure A to A5 within a period of 30 days from the date of receipt of a copy of this order. Needless to say, until such orders are passed, the respondent shall not dispossess the petitioner from the subject lands.
Please.
Please, Lord. Break to-
22, Pawan Dodati.
Correspondence.
After disposal of RA being filed by the petitioner, lords, since the suit schedule property was not reflected in the decree copy, an application was made for correction of the decree mentioning the suit schedule property. That application has been rejected, saying that, lords, I have to approach the trial court by filing a amendment application. Virtually, lords, in RM, lords, I have sought for correction of the decree. In the trial court, lords, OS decree, it is already mentioned. Virtually, the appellate court has asked the trial court to amend its lords decree.
You are asking for a correction of a mistake.
Please, in the decree of the RA.
Who has committed the mistake?
Lords, it is due to the technical, lords, mistake.
Technical ಹೆಂಗಾಗತ್ತಪ್ಪ? The decree has to be corrected by the same court.
Please, the appellate court. We have made an application before the appellate court.
As the appellate court passes a decree.
Please. Appellate court has passed.
ಯಾವ decree ತೋರಿಸಿ?
Annexure, lords, D and E. E is the decree, lords, which has allowed them, lords, appeal. And in page 59, lords, at serial C, it is declared that the plaintiff is the owner of the suit property. After suit property, lords, have sought for insertion of the suit schedule property, which is not done.
Suit property go scheduled property gain difference.
Please.
What is the
Entire
difference
property was, since the entire property was not described, lords, describing the boundaries, lords, and survey number, I had made an application for correction of the decree to mention.
Passed by the RA court.
Please.
Issue notice to the respondents.
Lords,
returnable
already
by-
they have applied.
Please, my lord.
And
We'll allow it.
even though they have also stated that they
They
have
submit that you would be appearing for respond number 1 and 2. Petitioner is before this court seeking for the following reliefs. The petitioner had made an application under section 152 of the Code of Civil Procedure for correction of a decree passed by the regular appeal court in RA number 30 of 2019.
Rahul.
The contention of the learned counsel for the petitioner is that in the decree which had been passed, the suit schedule had not been properly described, and what has been mentioned was only the suit property. As such, the petitioner had sought for the insertion of the suit schedule property in para C of the operative portion of the decree. The said application came to be rejected by the first appellate court on the ground that the petitioner would have to move the trial court, stroke the original court for correction, since a decree had been passed. A perusal of the documents indicates that the decree had been passed in RA 13 of 2019 and not by the trial court, after appreciating the contention raised by both the parties. If that be so, the decree having been passed by the First Appellate Court in RA number 13 of 2019, the First Appellate Court could also have carried out the necessary correction as sought for by the petitioner on and consider the same by considering the same on merits, instead of rejecting the same by directing the petitioner to approach the trial court for correction of a decree drawn up by the First Appellate Court. In that view of the matter, I pass the following order. Writ petitions allowed, a certiorari is issued, so and so is quashed. The matter is remitted to the Principal Civil Judge and JMFC Mudor, seized of RA number 13 of 2019, to consider the application filed by the petitioner under section 152 of the CPC and pass necessary orders within 15 days from the date of receipt of a copy of this order in terms of the above observations.
Please. Okay.
43, Chetan Limbikai.
I was supposed to provide the calculation. The outstanding amount is 16,28,833.
Let's petitioner has also made a millets.
16 lakhs?
16,28,833. I have given the statement, bank statement.
16 lakhs.
ಕೆಳಗಡೆ ಇದೆ ಸರ್ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಾಗೆ
overdue as on date 15 lakhs.
15,75,000. Net accrued interest 53. Both together.
Total ಎಲ್ಲೂ ಹಾಕಿಲ್ಲ ನೀವು?
Total ಹಾಕಿಲ್ಲ ಸಾಹೇಬ್ರು.
ಹಾಕ್ಬೇಕಲ್ಲ. 16 lakhs ಏನಂದ್ರಿ?
16,28,833.
Yes, Mr. Chetan.
Millets, petitioner has also made a millets representation for one-time settlement. That's on 13/2, which is pending for consideration.
You are in EP, there is no one-time settlement. ಇವಾಗ ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ ಅದೇ this matter may be referred for mediation millets.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಹೇಳಿ?
ಈಗ already 2 lakhs deposited before this court.
ಆಯ್ತು, ಅದಾದ್ಮೇಲೆ 16 ಲಕ್ಷ ಇದೆ.
16 ಲಕ್ಷ. Let's I will verify and let's make my submission.
You are supposed to verify and make the submission.
ಅಲ್ಲ today morning they have given this document.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದು ಇವತ್ತು
ಅದೇ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ.
16 lakhs.
Learned counsel for the bank submits that the dues as on today is rupees 16,28,833. Counsel for the petitioner seeks for and is granted a week's time to make a submission as to in what time frame the entire amount would be cleared.
Please.
Relist on 24th at 2:30 PM. Interim order earlier granted is extended till next day.
16 lakhs is as on 3/2/2025.
As on 3/2/2025.
44, BB Bhajantri, Ballari.
This case, my lord.
Present Avinash Mali Patil, not he undertakes to file wakalat for respond number 1, my lords.
Avinash Mali Patil submit that you will be filing wakalatnama for respond number 1. Registry direct print his name as such. R2.
R2, my lord, I'll take steps, like fresh steps, my lord, since I was already taken.
Petitioner seeks for a week's time to make payment of necessary process fee in respect to unserved respond number 2.
And I complied with the order of this honorable court, my lord, regarding deposit of 3 lakhs, my lord. I have deposited.
He has not told me about that.
I have filed a, my lord.
Needful is done by 28th. Issue notice to respond number 2 returnable by 29th April. Submission of learned counsel for the petitioner that the amount of rupees 3 lakhs has been deposited.
Deposited.
On record.
Interim order maybe.
Granted is extended till next date.
Interim order, my lord. Please.
45, Basuraj, Basangoda.
Took the objection number 43, 3, 5 and 10 minutes. I made a submission saying
Counsel
that.
for the petitioner, no submission.
ಅಲ್ಲ ಸ್ವಾಮಿ ಅದೇ petitioners number
ಇದೆ ಇಲ್ಲಿ submission.
That's
43,
4,
3, 5 and 10.
9, 4, 9, 18 and 23 dead mallards. Their legal aids are came to be.
ಈ submission ನಮ್ಮ ಮುಂದೆ ಏನಕ್ಕೆ ಬರುತ್ತೆ? ARJ ಮುಂದೆ ಹೋಗ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ another
ARJ is to deal with it. Fourth time your submission ಮಾಡಿದ್ರೆ first time ಮಾಡಿಲ್ಲ.
Afterwards, they raised one more objection, not well complaint.
Registry has put up this file with the council's submission. Whenever any submission is made by the council as regards office objection raised, the matter is required to be placed before the additional registrar judicial for necessary orders.
And my lords,
In that view of the matter, registry is directly place the above petition before the additional registrar judicial for doing the needful. The additional registrar judicial is also directed to issue appropriate instructions to the concerned that even if submissions are made on office objections subsequent to the matter being listed before this court, the same to be placed before him for necessary orders.
with respect to another subsequently they raised objections. I may be
Comply.
permitted to comply.
Counsel for the petitioner is permitted to comply with the other office objections.
Please,
Don't make this court into clerical. Alle ಮಾಡ್ಬಾರ್ದು.
please.
46, Vidyashankar Dharwad.
Same order.
47,
Interim order.
Shilwan.
Interim order.
Interim order is extended.
47,
Same order.
48,
10 days time is granted. ಮಾಡಿಲ್ವಾ? ಯಾರಪ್ಪ ಬಸವರಾಜ್ ಬೈಕೋಟ್? Mr. Baicourt,
Suraj Backward,
Batkurki.
NL Batkurki,
ಇರ್ತಾರಲ್ಲ ಅವರು. 10 more days time is granted to the counsel for the petitioner to make payment of the process fee. If needful is done by 28th, issue notice to unserved respondent, returnable by 29th April. Needful is not done by 28th, released on 7th March for dismissal.
Lord, one submission. Pass or
114.
114, Sachin Angadi.
Lordship has directed the state to
My lord, on the last occasion, the lordship has directed, as on the date of conducting raid, whether the soil was on the petitioner's property or not, and to ascertain and to make submissions. My lord, may I pass on the Panchanama which has been drawn?
Eleven 21.
Yes, this was,
Yes, Renu.
my lord, impugned annexure was passed on 4/5/2022.
Bhagwan.
Prior.
ಯಾವ ಹಳ್ಳಿ ಇವ್ರದ್ದು?
ಅವ್ರದ್ದು ಟಿಕ್ ಮಾಡಿದ್ದೇನೆ. I have ticked just in so far as
Security
petitioner
village.
is concerned.
ತಪ್ಪ.
Yes,
Algur. 2904 metric
yes.
tons.
Thereafter, my lord, proceedings were conducted, notices were issued. He did not appear before the concerned authorities. And thereafter, this order has been passed. Steps have been taken in the year 2022.
ಆಮೇಲೆ this has been auctioned, ah?
ಅಲ್ಲ, ಇನ್ನೂ ಆಕ್ಷನ್ ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
ಇನ್ನೂ ಅಲ್ಲೇ ಇದೆ.
ಅಲ್ಲೇ ಇದೆ. We have passed an order directing to take under the proceedings under the MMDR Act as well as under the to enter the encroachments. That order has been challenged.
To take action.
Yes.
Yes, Mr. Angadi.
My lord, in this case, my lord, what happened, ma'am? As per the alleged, my lord, state government, my lord, first of all, my lord, it's the agricultural land, my lord. It is a open land, my lord. Before, my lord, at the time of seizing the soil, my lord, they are not issued the notice to me, my lord. And my lord,
They are going to file proceedings under MMRDA case. MMRDA. You can agitate your defenses there.
my lord, moreover, my lord, they are not filed, my lord. They are not filed the MMRD case against me.
ಫೈಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
My lord, their incident, my lord, there is lapse of delay, my lord.
ಯಾವಾಗ ಇದಾಗಿದೆ?
22 the 25.
ಮಾಡಿಲ್ಲ 22 ಇಂದ ನೀವು.
ಅಲ್ಲ, ಅದು in so far as initiating under the MMDR, I have not secured any information.
And my lord,
ಅಲ್ಲ,
ಮತ್ತೆ
ಅಲ್ಲಲ್ಲ, within 5 minutes I will check and make a submission insofar as that is concerned. But insofar as the challenging the 2022 order in the year 2025, wherein pursuant to which, my lord, when a spot inspection was conducted in his presence, we found that there was an illegal storage of sand in his property. For that reason, my lord, Panchanama was drawn. Thereafter, we issued notice why your and the other persons, why necessary steps should have not been taken in spite of there being an illegal that is, in spite of notices to all the 75 members, out of which, my lord, about 45 members appeared and they have given their explanation. But insofar as the petitioner is concerned, he did never turn back. So steps have been taken to enter under the Land Revenue Act to encumbrance. At least you would have
My lord,
submitted.
first of all, my lord, there is a open land, my lord. And my lord, who has dumped, my lord, first of all, it is, soil is not,
ಏನ್ರಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ 10 ಗುಂಟಾದಲ್ಲಿ 2904 ಮೆಟ್ರಿಕ್ ಟನ್ಸ್
my lord, it is not pertaining to me, my lord.
ಮತ್ತೆ ಹಂಗೆ ಸುಮ್ನೆ ಇದ್ಬಿಟ್ರಾ ನೀವು?
It is not pertaining to my lord.
ಅಲ್ಲಪ್ಪ 2904 ಮೆಟ್ರಿಕ್ ಟನ್ಸ್
Yes, my lord.
ಅಂದ್ರೆ ಎಷ್ಟಾಯ್ತು? ಒಂದು ಟ್ರಕ್ ಅಲ್ಲಿ 10 ಟನ್ನು.
Yes, my lord. Even the, my lord, Panchanama, my lord, what for the,
So you are speaking of 3000 truckloads.
yes, my lord. My lord, it is not pertaining to me, my lord. And moreover, my lord, they are not issued, at the time seizing, my lord, they are not issued to notice to me, my lord. And my lord, second,
ಬಂದ್ ಯಾರು ಡಂಪ್ ಮಾಡಿದ್ದಾರೆ ಬಂದ್ ನೋಡಿ ಅಂತ ಏನಾದ್ರು ಹೇಳಿದ್ರೆ ಯಾರಿಗಾದ್ರು?
no, my lord, even, my lord, I am not at all aware regarding that, my lord.
You are not aware.
Yes, my lord.
We can believe you on that.
My lord,
We
what,
believe that. It's not one truckload, it's
my lord,
2904
my lord,
metric tons.
what the prosecution, the Panchanama, my lord, what they have said, my lord, 11/11/2021 my lord, ರಂದು ಅಕ್ರಮ ಮಣ್ಣನ್ನು ಶೇಖರಣೆ ಮಾಡಿ ಇಟ್ಟಂಗಿಗಳನ್ನು ತಯಾರಿಸಿ ಮಾರಾಟ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ದೂರು ಪ್ರಯುಕ್ತ, my lord. My lord, same, my lord, if ಈ ಪೆರುಜ್ ಅಳತೆಯನ್ನು 9 ಗಂಟೆಯಿಂದ ಸಾಯಂಕಾಲ 6 ಗಂಟೆಯವರೆಗೆ ಪಂಚನಾಮವನ್ನು ಆಧರಿತ ಅಧಿಕಾರಿಗಳು ಸಮಕ್ಷಮ ಗಣಕ ಯಂತ್ರ ಟೈಪ್ ಮಾಡಿ ತಯಾರಿಸಲಾಯಿತು. My lord, if you believe, it is unbelievable, my lord, 9 ಗಂಟೆಯಿಂದ 6 ಗಂಟೆಯವರೆಗೆ, my lord.
It's unbelievable that you did not know.
My lord,
Standard ಅದು ನಿಮ್
my
land
lord,
ಅಲ್ಲಿ.
my lord, there is a, so many metric tons, my lord, out there, they are wave the, that metric tons, my lord. And my lord, how they are seized that, my lord, ಅದನ್ನ land ಇಂದ ಹೇಗ್ ತಗೊಂಡೋದ್ರು, they are not at all mentioned, my lord.
You can't impose this penalty until you initiate proceedings and MMRDA.
Immediately action would have been taken.
MMRDA ಮೇಲೆ ಹಾಕ್ಬೇಕು. Without that, how do we do this? And you have not done that in last 2 years.
Alla,
3
insofar,
years.
alla, insofar as initiating under the MMDR, that might have been taken place. I will place and place before the lordship.
Learned AGA seeks for a day's time to obtain instruction, make a submission as to whether any proceedings have been taken against the petitioner under the MMRDA. Released on 19th at 2:30 p.m.
Please.
Yes. My lord, may I make on the answer xerox, my lord, what the,
ಅಲ್ಲ ಅದು ಅವ್ರ ಕಡೆನೇ ಇದೆ.
ಒಂದೇ
ಪಂಚನಾಮ
ಅದು
ಮಾಡಿದ್ದು ಅವ್ರ
ಪಂಚನಾಮ
ಕಡೆನೇ
ಒಂದ ಕೊಟ್ಟಾರ ಸಾಹೇಬ್ರ ಅವ್ರು ಎಂಟೈರ್ ಕೊಟ್ಟಾರ, ಅದನ್ನ ನೋಡಿ ನಾನು ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೋದು ಸಾಹೇಬ್.
Stand ಖಾಲಿ ಮಾಡಿ.
My lord, even, my lord, there is no principle of natural justice, my lord.
And mining is the worst thing that is happening today.
Yes.
Sand ಹೋಗ್ಬಿಟ್ರೆ ರಿವರೇ ಇರಲ್ಲ.
Yes, my lord.
ನೀರಿರಲ್ಲ ಆಮೇಲೆ.
Yes, my
And
even, my lord,
satellite technology ಏನ್ ಮಾಡಿದಿರಾ?
Please.
We had asked you to check whether you have used satellite technology to keep track of the riverbed.
ಇಲ್ಲ, I will get information. ಅದನ್ನು ಪ್ಲೇಸ್ ಮಾಡ್ತೇನೆ. Yes.
And AGA to also place on record whether satellite technology has been harnessed to keep track of the,
On the last occasion also.
to keep track of
FSL
the.
report, my- if
Last
any
time
FSL
ಅದನ್ನ
report.
ನೀವೇನ್ ಮಾಡಿಲ್ವಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲ.
my lord, no, another
Keep
one.
track of illegal sand mining on riverbeds.
If any FSL report, my lord, if the sand is seized, my lord, if same is, ಅದನ್ನ ಅಲ್ಲಿಂದ ತಗೊಂಡಿದ್ದು FSL ಗೆ ಏನೋ ಕಳಿಸ್ಯಾರಂತ ಅದೊಂದು ರಿಪೋರ್ಟ್, my lord.
ಈಗ MMRDA ತಗೊಂಡಿದಾರ ಅಲ್ಲಿ ಅದೆಲ್ಲ
Yes, my
ಇಲ್ಲಲ್ಲ.
because, my lord,
ಆಯ್ತು ಎಸ್
Lord, serial number.
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು 84 released on 13th March. Interim order. Appear. File ಮಾಡಿ.
That's serial
52 released on 13th March.
Serial number 91.
ಹಾ,
Serial number 91.
ಹೇಳಿ.
ಸರ್ ಅಲ್ಲಿ ಸ್ಟೂಡೆಂಟ್ಗೆ ಮಾರ್ಕ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, 260 ಮಾರ್ಕ್ಸ್ ಕೊಟ್ಟಿತ್ತು. 260 ಮಾರ್ಕ್ಸ್
Education matter,
ಕೊಡ್ಬೇಕು.
91.
91. Because of COVID-19, ಅವ್ರು ಆ ಎಕ್ಸಾಮ್ ಕೊಡಲಿಲ್ಲ. ನೆಕ್ಸ್ಟ್
Release
ಎಕ್ಸಾಮ್
ಆಗಿದೆಯಾ?
ಗವರ್ಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಮಾಡೆಲ್
91 released on 19th at 2:30 PM.
Serial number 87.
ಹಾ,
82, my lord. I request for 230. Short.
ಏನು
87.
ಏನಪ್ಪ
I request for 230 day after 2.
ಅರ್ಜೆನ್ಸಿ ಏನ್ ಹೇಳಿ?
Agency is, I am the owner. My award is passed in my favor. That is not released in my favor.
Execution.
Seal number 103.
ಅದಾದ್ರೆ execution.
Seal number 103, my lords.
That is not.
Last time, my lords, Holla sir appeared in this matter and mentioned at 2:30, my lords.
Yes.
2:30 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೊಳ್ಳ ಸರ್ ಕಿರ್ಲೋಸ್ಕರ್ ಮ್ಯಾಟರ್.
Released on 19th at 2:30 PM.
24th.
My lords, can it be taken on 24th, my lords?
24th at 2:30 PM.
Serial number
Please,
58, my
please.
lords. Kindly be tomorrow, my lords. Serial number 58, my lords.
58. ಏನಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಅಷ್ಟು ನಾಳೆಗೆ?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, my lords. ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಅಂದಿದ್ದಾರೆ, ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆ, my lords. So kindly be tomorrow.
Entry order ಇದೆ ತಾನೆ?
Yes, ma'am.
There is no entry model.
Interim.
Executive court is threatening to close the EP itself. A very simple point is involved.
ಸಿಂಪಲ್ ಪಾಯಿಂಟ್ ತಗೊಂಡವರೆಗೂ 58 released on 19th at 2:30 PM.
19th.
ಯಾವತ್ತಿದೆ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅದು
19th ಅಲ್ಲೇ ಇದೆ, sir.
19th ಇದೆ ಮೇಲೆ.
Released tomorrow at 2:30 PM.
ನೋಡಿ serial number 109. 109 ನೋಡು.
ಹಾ,
Day after tomorrow, my lord. This is Uttaradi Matta matter, my lord. My lord already heard that Amit Kumar Deshpande, my lord, senior advocate. All day after tomorrow, my lord.
how long will you take to argue this matter? ನೀವು ಬಹಳ ಟೈಮ್ ತಗೊಂತೀರಾ?
This matter pertains to Uttaradi Matta.
Day after.
ಉತ್ತರಾದಿ ಮಠ 20 ಮ್ಯಾಟರ್ ಇದೆಯಪ್ಪ, ಎಲ್ಲ ಮಠದ್ದು ಯಾವ್ದು ಯಾನು?
ಈ ನಂಬರ್ ಆಗಿದೆ,
ಈ number.
24 ಆಗಿದೆ.
2017 month.
109 released on 19th at 2:30 PM.
Great.
Serial number 70, my lord.
70.
Entry murder extended. Entry murder extended.
ಏನಪ್ಪ?
Entry murder extended, my lord.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇನೆ sir.
Serial number
91 next week.
Serial number 60. Any date next week or.
ನೋ ಅರ್ಜೆನ್ಸಿ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗ್ಬೇಕು ನೀವು ಅವಾರ್ಡ್ ಬಗ್ಗೆ.
ಅದಲ್ಲ, ಅದು ಬೇರೆ. ಅದು ಬೇರೆ. ಇದು
ಇನ್ನೊಂದು ಇನ್ನೊಂದು ಏನು?
let's petition is a KSRTC driver.
ಹಾ,
ಅದು ಅವನ ಮೇಲೆ ಈಗ ಲೇಬರ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ KSRTC.
ಹಾ,
ಅದು ಇನ್ನು 2010ದ ಆರ್ಡರ್.
ಅರತ್ತೆ ಬಿಡಿ. Yes.
ಒಂದು ಡೇಟ್.
ಹಾ. ಏನು? 81 ಅಕಾಮಿಡೇಷನ್ ಎಲ್ಲ ಕೊಡಿ.
ಅಲ್ಲ.
ಎಸ್ ಮೇಡಮ್. ಹಾ, ಏನ್ ಹೇಳಿ? ಅಷ್ಟೇ ತಾನೆ?
let's all.
ಹಾ, ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್. ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಎಲ್ಲದರಲ್ಲೂ ಸಿಗತ್ತೆ.
My lords, one submission. In serial number 67, terminal benefits are withheld by the my lords.
It will have to be heard.
2010, my lords.
It will have to be
ಅಲ್ಲ,
heard.
ತಾವೇ ಮೊನ್ನೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ರಿ, ಅವ್ರೇನಾದ್ರು MUC ಅಲ್ಲಿ ಏನಾದ್ರು
ಅದ್ರಲ್ಲಿ ತಗೊಂಡಿದ್ವಾ?
ಅದ್ರಲ್ಲಿ
ಪಾರ್ಟರ್ಡ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಮತ್ತೆ. ಸೇಲ್ ನಂಬರ್
67.
67 20th at 2:30 PM.
Please. One submission. Adu serial number 113. I have already given a NOC. My name is 113. Prashant Ai Gowder anta torusa. Already given NOC my return.
And 13 ಶಿವರಾಜ್ ಮುದೋಳ್.
ಹೌದು, ನಾನು NOC ಕೊಟ್ಟಿದ್ದೀನಿ already. I already given NOC. My name is reflecting.
ಶಿವರಾಜ್ ಮುದೋಳ್ ಹೆಸರು.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ ಪ್ರಶಾಂತ್ ಗೌಡ್ರ ಅಂತ.
ಪ್ರಶಾಂತ್ ಐ ಗೌಡರ್ ಅಂತ ತೋರಿಸಿ.
ಅವ್ರ ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಆಮೇಲೆ ನೀವು NOC ಕೊಟ್ರೆ ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿ. Then we will consider.
Sir, 81 and 101.
Court officer, sir. 103 ಇದು. Serial number 103. ಅದು 2:30 next week ಅಲ್ಲ sir? 24th ಅಲ್ಲ sir? 103. 103.
24 to 2:30.
Thank you sir. Thank you.
59 minutes.